66 of the Judicial Code. Quote, every receiver or manager of any property appointed by any court of the United States may be sued in respect of any act or transaction of his concerning the business connected with such property without the previous leave of the court in which such receiver or manager was appointed. Now this goes, there's a few more. But the point is, there's already precedent detailing the distinction between bringing suit in a state court and then having it removed to the federal jurisdiction, and also acknowledging what's required to legally hold a judge even responsible for what happens during the course of being appointed as a receiver. Questions may abound. What if you were a member of the Judicial Branch at some point in time, especially involving matters related to real property, bankruptcies, and then become a legislator? You know, there's precedent already for what happens in connection with somebody who ends up serving in public office in a legislative role, who had something that might present conflicts of interest concerning their role previously in the judicial branch. That precedent exists as well, and you will be addressing those matters very shortly. Precedent also exists for understanding what it means to address that you do not have to list within the original charge the justification for allowing removal from a state court to a federal district court. And the cases of appealing to a reconsideration in the district court of the facts as brought in the original effort. And there's a very specific role, a distinction between when it's appropriate for habeas corpus versus other kinds of judicial relief. I just got that from one case. One case after I stopped and did what needed to be done to avert a course of action wherein individuals that were prominent parts of the United States government who happened to be of Jewish descent were not merely just used as the basis for issuance of stock with the intention of it being converted to use by and for somebody else that was not Jewish, right? And these cases are part of the public trust of the people. And if you're putting yourself in a position where you're representing the people and you have access to that information that I had access to, but refused to represent me, then I have every right to be represented in a manner that actually reflects the Constitution, as opposed to whatever else was allowed to justify denying me personally any access to rights of due process for now what appears to be 35 years, but at least actively for 5. So all of this is going to be put into an appropriate written form, but we're getting into the same problem we had in December of 2020, where the appropriate procedure needs for the local interlocutor to understand, again, it is not their jurisdiction to obstruct and create a completely inappropriate attempt to compel a kickback locally for something that needs to be put into another matter. I'm not going to file paper on site with a clerk of the court that has a very specific fiduciary responsibility when it comes to processes involving the administration of justice, when I already know it's not appropriate? I already know it's actually illegal and it's part of the charges that were stated as fact in the original filing, which already went before the local district court in a request for a new trial. That was done what with, right? So I have what I need. And what you need to do is start getting all of the evidence that you haven't shredded or attempted to illegally privatize to be repackaged as a financial product, connected to what ended up happening with the subsidies that were given out as part of the Troubled Asset Relief Program, as opposed to what the original intent of the Troubled Asset Relief Program was. Specifically, banks, major banks that were in a situation of potential insolvency but got some other accommodation that apparently to this time has not been appropriately reconciled. See, these were a part of the facts that needed to be addressed through the appropriate administrative process, as opposed to continuing to try to hook up bigger and bigger and bigger scores further down the pipeline. Because now we've got a lot of people that are on the chopping block that would not have been on the chopping block in December. And that was already known. And that's going to be one of a number of crimes we're going to have to deal with very soon.